Ski Accident Cases, Massachusetts. Good afternoon. I'm attorney Neil Burns. Along with my partner Roshan Jain, we represent victims of ski accidents and other type of accidents that are covered by homeowners insurance policies in Massachusetts. This particular case took place in Vermont, but our client was from Massachusetts, so it's a Massachusetts case. We can file suit in Massachusetts. He was a skier. He was a competent skier, an experienced skier, and quite the athlete. He was skiing with his wife, and he stopped to wait for his wife. Unfortunately, a snowboarder came flying down the mountain, collided with him, made him fly out of his skis. His bindings and his skis stayed still. He went flying down the hill. And the collision caused a broken ankle, broken right ankle, and landing on the ground caused a broken bone in his rib, which punctured his lung, therefore resulting in him having to be in a hospital for several days to have the lung drained. The insurance adjuster on the case admitted all of this, admitted that there was a problem, admitted that her insured snowboarder had rammed him from the rear, and admitted that they maintained liability, that they would pay. And they offered a small amount of money to show their willingness to pay, and said they would mediate the case. So we went to mediation. And here's where the problem started. The insurance defense attorney decided he would change the facts, change the law, or misrepresent the law. So what he said was that our client stopped in a collection area where there were a lot of people, and it was confusing, and you assume the risk if you stop in an area like this, if you're skiing, which is a very dangerous sport, he said. And however, we proved, because our client had a Garmin watch, one of those watches, unlike an old-fashioned watch like I have, but the kind with the computer in it. So we printed out where he fell, and you can see he came down and he stopped right here, nowhere near a collection area. Collection area is up here, and nowhere near a dangerous place. It was the side of a trail, far from anyone else. Far from anyone else. It had no relation to where anyone else should be skiing. He was privately skiing in that spot. Unfortunately, the defendant rear-ended him and hit him there. So he had the facts wrong. He misrepresented the facts, even though he knew what they should be. Secondly, he misrepresented the law. The law is general negligence law, to simplify it. And he cited a case, a 1995 case, that said that anyone who skis assumes the risk, and therefore our client assumed the risk and should not be compensated at all. He didn't cite the 2016 case, the recent case, which said assumption of the risk has to be proved by the defendant. That's a burden on them. If they think that there's some sort of risk that was inherent in what the person was doing, they have to prove it. So the insurance attorney misrepresented the law to the mediator and, of course, to us. And I think this put his case in a disadvantaged position. He was disingenuous. He was dishonest. He was deceptive. The case settled at mediation because we were aggressive and we were effective. We pushed aggressively to get our client an excellent six-figure result. If you've been injured in a ski accident and you have a case against another skier and you know who the skier is or was, there may be some relief. Give us a call. Burns & Jain, 617-227-7423.